Thank you. Thank you, Dr. Zhang, for setting our conference up today and my ability to present this topic to everybody. I am a lawyer. I'm a lawyer that has practiced for approximately 20 years in the defense of physicians and healthcare facilities in Texas. And my topic today is healthcare liability claims and liability for emergency care. I've broken up the presentation into three general areas. The first will be some basic background information of the healthcare liability law in Texas, how it came about. The second will be the basic areas of any liability claim against a healthcare provider and the basic steps of that claim and the type of evidence which is key, of basically a thumbnail sketch of a lawsuit and defense against a lawsuit against healthcare providers. The third part of the presentation is broken down into the primary areas that are hot button topics in emergency care medicine when it comes to liability. The first is the application, the day-to-day application, and kind of missteps, potential missteps that can happen in an EMTALA claim. The bifurcation from that would be the standard of proof that is required of a family member or plaintiff or person bringing a lawsuit against a healthcare provider, and in particular emergency room physician or emergency care. The burden of proof that is required on them is different than the typical healthcare liability claim, and I want to share my thoughts on that issue as well. My name is Edward Castillo, and we'll move forward from here. Next slide, please. So the basic history in Texas of healthcare liability law is kind of the most recent or predecessor statute to the current statute was a statute called 4590I, which is often referred to as 4590I. And that was originally codified in 1977 by the legislature. It had some basic protections, but it was more theoretical than applicable regarding those protections. In particular, it had a protection that a healthcare provider was required to receive notice before a lawsuit was filed in order to discuss potential resolution of the case, or be provided an opportunity to investigate the claims that are being made in regards to liability, in regards to the actual compensated damages that were being sought, or in regards to any causal connection between the claimed liability and injury or damages. And the 4590I also required initially that an initial expert report be provided to the healthcare provider in order to give some basic understanding or merit to the case. Next slide, please. Towards the end of 1999 and first part of 2000, 2001, leading up to the 2003 legislative conference, there were a big kind of push by the healthcare providers to recodify and tighten up some of the kind of loopholes that were in the 4590I statute that should make it more difficult for a party to bring forth a lawsuit against healthcare providers. And so in 2003, laws were changed into a Civil Practice and Remedies Code, Chapter 74, which the law is now often referred to as the Chapter 74 Healthcare Law. Next slide. The primary, before I get into well, on this slide, I kind of depict what the very basic thumbnail sketch of any lawsuit is, including a malpractice claim, which is that there's some issue of care, whether that was a hospitalization whether that was an emergency room encounter, whether that was an encounter at a clinic where a procedure occurred or lack of procedure occurred, and a family member or a claimant or the patient decides that they will need to seek the advice or counsel of a lawyer that does the work against healthcare providers, and that lawyer decides to proceed with a lawsuit. At that stage, usually there's from the lawsuit stage to the trial stage, which is the biggest stage in any lawsuit, is called discovery. And during that discovery phase, a healthcare provider, including the physician, may be asked to give a deposition. That is being placed under oath and having to answer questions regarding your care, care of others, and whether or not that care led to injuries or potential damages to the claimant or person bringing the lawsuit. And they can be lawsuits from unintended care to unnecessary care to too aggressive of care. In the emergency room setting, the traditional factual pattern is that someone comes to the emergency room, they receive care, they're discharged, and then subsequent to the discharge, some adverse event occurs. The classic one is someone comes in with epigastric pain, they're evaluated, they get discharged, they go home. Within hours or days, they suffer a myocardial infarction, and the claim is that there was sufficient information upon the emergency room visit to have diagnosed the potential or oncoming MI, and the discharge should not have occurred. It always almost exclusively revolves around the discharge in emergency room cases. So next slide, please. Without getting too far off topic, I want to talk about basically some key provisions of the Chapter 74 current law that governs lawsuits against healthcare providers. Under the new law, a claimant is required to request via a medical authorization and a notice letter that medical records be provided. And the new law provides a healthcare provider 45 days to produce those medical records, so long that a compliant, HIPAA compliant authorization was received, or a medical authorization that is outlined under section 74.052 of Chapter 74, which is akin to a HIPAA compliant authorization, but it does have additional requirements. And most often you will see a claimant, if they're represented by a lawyer that is familiar with this law, they will simply send the 74052 authorization, because it covers a lot more basis than just the traditional HIPAA compliant authorization. Next slide, please. Under the old law, the primary change was an expert report. The old law had an expert report that must be filed, and that must be filed was very ambiguous and very loosely applied. And oftentimes there was no expert report filed by the claimants, and the case proceeded forward without a report, and you would not get an expert report until very close to the time of trial, at which time a lot of expense, time, and effort had been put into the case, which caused healthcare providers to lose a lot of time, potential patients to lose available resources, and also the insurance companies that insure the healthcare providers to expend a lot of costs on behalf of that healthcare provider. So there was an increase of premiums resulting from a lack of real diligence in applying the 120-day expert report rule. So the new law in 2003, and which is still currently being litigated in many instances, is requires that a claimant shall within 120 days of the physician answering the lawsuit, they must, and they shall produce an expert report. And the legislature in this instance put a lot more teeth behind that shall than they had previously done behind that must requirement. And now the law is very strict in that if there is no expert report filed by the claimant within that 120-day period of time, that being the 120th day is the last day they can file the report, that if no report is filed by that time, the case must be dismissed. And that law has been very strictly applied in favor of healthcare providers, that even if it's 1 day late, it does not qualify and cases should be dismissed. It also has eliminated any outside kind of excuses or perceived reasonable things that may have led to tardy reports. So Chapter 74 has put a lot of teeth into that initial report requirement. Next slide, please. Some of the bigger changes, which is what has been in effect since 2003, is the damage cap. And there's often sometimes confusion on what is capped and what is not capped. And the damage cap only applies to non-economic damages. And that damage cap for all physicians involved in a lawsuit is $250,000. If there's a healthcare institution, a hospital, then they have a separate cap of $250,000. If there's two institutions in the lawsuit, then that second institution also has another $250,000 cap, which means per claimant, they cannot receive more than $750,000 in non-economic damages. And the usual question on this is, does $250,000, is that per physician and per claimant? And under the statute, claimant is defined as all people bringing the lawsuit. So it does not matter how many family members or how many patients, they all are perceived as one claimant. And the $250,000 damage cap applies to all physicians. So if there's 4 physicians in the lawsuit, the 4 physicians share the protection that there will only be one $250,000 potential award for the case. Now, this does not apply to economic damages. Those are a separate element of damages. Therefore, on cases where there might be a wage earner, or there was high expenditures on medical expenses, or there might be a claim for future medical expenses, all those fall into the category of economic damages, and those type of damages are not protected under the non-economic damage cap. Therefore, if there's two primary examples of this, if there's an alleged wrongful death case of a wage earner, that may be someone who is younger in age and still working, then that type of case has the potential of exceeding the $250,000 non-economic damage, because there may be a claim for other types of damages, that being wages, which are economic damages, future medical expenses, or expenses incurred from the time of the hospitalization to the time of death. So that may exceed the $250,000. There is a damage cap for death cases, and I didn't get into that, but that's around 1.8 to 1.9 million at the moment, because it is tied to the consumer price index. The other type of damages or types of cases that go over the $250,000 damage cap are cases involving, say, permanent neurologic injuries or injuries that are ongoing and require ongoing care for someone's either a short-term or sometimes long-term or sometimes life. A brain injury is one of the classic example, and there's a claim that that patient will require care, which is going to cost money for the entirety of their lives. And then there's always an argument is what is the life expectancy that should be attributed to those costs. And once you start adding up those and multiplying the cost per year over a life expectancy, then you can get well above the $250,000 damage cap into the millions or multiples of millions of dollars in those types of cases, in permanent neurologic injury cases. Next slide, please. One of the concepts that I always try to impress on physicians and healthcare providers is the concept of you need to know your environment as far as when you're providing care, and you need to be cognizant of what you're saying, how you're saying it, and who is listening and not listening, because anyone around the room, that being plaintiff, family members, the patient, other doctors, nursing staff, those first four categories on this slide are people that you have a lot of control over as to what they're going to say, just in the manner in which they are communicated with, the manner in which your documentation is reflected, your communication is with these individuals, and your kind of relationship with these individuals. If you always maintain kind of a professional atmosphere, then oftentimes you can have a lot of control over what those first four category of witnesses can say about your care and about your delivery of care. The last category of witness in any malpractice case is an expert witness. That is someone that is paid to give an opinion from an outside perspective. They're hired by both the claimants and by defense lawyers like myself to support the care and defend the care that is being the subject of the litigation. Go on to the next slide. And along some of those same lines, the key pieces of evidence, the number one piece of evidence in any malpractice case is the medical record. And I cannot stress that enough. When the documentation of your notes, of your observations, of your history and physical are front and center and blown up as big as this slide is blown up. And inevitably, no medical record is perfect, no entry is perfect, but in today's environment and where healthcare has gone and where it is today in regards to documentation is that every medical record almost exclusively is electronic. Some physicians are very adept and efficient on documentations, others are not, depending on just who you are. But that is a skill that needs to be developed and developed very well because medical records and the documentation of medical records is a key aspect. And there is a lot of drop-down menus, and those drop-down menus are becoming more and more prevalent as physicians have input into the electronic service providers and what they think should be in the medical record. And doctors, nurses, techs, everyone gets kind of lulled into sometimes being dependent on those drop-down categories or being too concise or overly concise in the whole process of documentation. And you just have to be cognizant that it should be a well-explained note where it removes ambiguities, and notes should also include, to the best abilities, conversations with other healthcare providers of what information was transmitted among the quote-unquote team that is providing care. That is often a saving grace for many healthcare providers as far as whether you communicated certain pieces of information. The other key areas of evidence at any malpractice trial will obviously be the deposition testimony, and preparing for the deposition is key. Other aspects are what is your board's regulations, Texas Medical Board, whether you complied with those boards, any standards that may be outlined in the literature as far as handling a particular situation. Those are always key pieces of evidence as well. Next slide, please. So in regards to just general proof of a regular malpractice case, I want to start off with that. The question that a jury is asked is whether or not the physician or emergency room physician acted in a way that is ordinary, and how others would have acted under the same or similar circumstances. So it is not a requirement that there be extraordinary care, just ordinary care. Some people describe it as, if you ask 100 physicians, would 51 side on the way that you provided care? If 51 side your way, then that would meet the definition of ordinary care. So what is negligence, which is the ultimate question, or the cause of action that is a malpractice case? It is whether or not the physician was negligent or not, is whether or not you complied with that standard of care, whether or not you complied with what 51% of physicians would do under the same or similar circumstances. There's another aspect of causation, of negligence, which is causation, which is whether or not that act of medical care or that omission of medical care caused actual injury. And that is always the second prong of any case, is maybe there is liability there, or maybe things could have been done differently, but the plaintiff, the claimant, the patient still needs to prove that alleged deviation in the standard of care caused the ultimate injury or death or substandard result or unexpected result or quote unquote bad outcome. So there's always two aspects to any case: liability and causation. So next slide, please. I'm going to switch gears at this time and talk about EMTALA. And EMTALA is not a state statute. It is a federal statute, which is something that's codified by the federal government. It is a statute that, by its very basic understanding, is an anti-dumping statute. It applies to any facility or surgical center or entity that has an emergency room, and it indicates that the facility, if it is a Medicare or Medicaid recipient facility, then EMTALA applies. And it requires certain aspects that the emergency room department do before discharging or transferring a patient. And the genesis of this statute was a codified statute that would prevent facilities or physicians to just kick people out that hadn't received kind of a basic screening. It was created to ensure all patients who present in physical distress to the hospital receive the same type of care. Next slide, please. So it was not created with the purpose of ensuring proper diagnosis or proper stabilizing treatment. So oftentimes when an EMTALA allegation is made, our first kind of process in trying to dismiss that allegation is to separate it from any aspect of whether or not there was liability or whether or not there was an injury. Our primary focus is in just establishing that the established process of evaluating every patient was followed. And while some hospitals may have stricter kind of checklists for every patient, under the precedent or cases that have been decided in federal court, a very basic understanding of the stabilizing and diagnosis process in facilities has been established. And that is, number one, do not ask about financial capabilities until the patient is stabilized. Number two, every patient gets triaged. Number three, every patient gets evaluated by a physician. And number four, every patient gets evaluated by a primary nurse, different than the triage nurse. If those basic five things are treated, then then there you have a good argument that the EMTALA process has been completed. Whether or not the diagnosis is appropriate or maybe was missed is a separate issue that falls under the malpractice statute, not the EMTALA statute. So EMTALA is more of a procedure and process type of argument, as opposed to whether or not care was appropriately administered or omitted. Next slide, please. So along those lines, EMTALA is not a substitute for state malpractice actions and was not intended to guarantee proper diagnosis or to provide a federal remedy for misdiagnosis or medical negligence. And this is more of a legal issue, but there is no federal malpractice law. So wherever you practice, if a lot of ER physicians have licensures in multiple states, then the governing law in regards to a negligence lawsuit as to your care will always be the state law. And EMTALA is just a federal protection on the process of preventing the dumping of patients. Next slide, please. So the basic requirements or duties imposed on a facility are to provide a medical screening, stabilizing care, make only appropriate transfers, maintain and enforce a physician on-call list, and accept incoming transfer requests. If you are a facility that falls under EMTALA protections or requirements, then and you get a phone call from a different facility with a potential transfer needing care at your facility, then the facility and the physician are required to accept that patient under EMTALA. Importantly, that requirement ends at the time that the patient is admitted. So all EMTALA duties, responsibilities end at the time a patient is admitted, which, not to go too far off our presentation here, I'll give you a brief example of how that plays out in a lawsuit that I handled, which was disposed of maybe a year ago. There was a 46-year-old male that was admitted to a emergency room with abdominal pain, chest pain, was diagnosed with 6-centimeter abdominal aortic aneurysm. There was components in the aortic arch of the aneurysm. There was some questions about how far up the aorta the aneurysm presented to. And the patient was admitted for further radiological studies to determine the exact type of aortic aneurysm that existed, whether it was type A or type B. And subsequent to the admission, the hospital determined that the type of aneurysm that this individual had could not be managed by the surgeons available to that hospital. So the process then initiated to attempt to transfer that patient out to other facilities that did have the physician capabilities. And every hospital that was contacted refused to accept that patient, mostly based on financial capabilities. And they could deny that transfer because the EMTALA protections no longer applied to that patient. If the request for transfer had come out prior to admission from that facility, the facilities capable of managing that patient would have been required to accept that patient, regardless of that patient's ability to pay for his or her care. So that admission process was highlighted, or that admission kind of threshold was highlighted in that case. And the claimant, the family members of this individual, because this individual was eventually not capable of being transferred, and the appropriate personnel to do the surgery were not available, and that aneurysm expanded. He it ruptured and the individual died in the facility. And the allegation brought against the emergency room physician and the hospitalist that evaluated the patient in the emergency room and who coordinated admission of that patient was that those physicians should have been aware and cognizant of the EMTALA protections available to that physician and taken that those aspects into consideration prior to admitting him to the hospital. And the defenses to that were the patient required close observation or closer observation and monitoring of his vital signs due to that expanding aneurysm that were not available in the emergency room, and therefore admission was required. But that's an example of how EMTALA can come into play even in circumstances that don't involve stabilization or the process. Next slide, please. Regarding definitions of medical screening, a hospital must conduct a medical screening examination to determine if a patient is suffering an emergency medical condition. And the key is the medical screening must be the same for all patients with same conditions. It is the key aspect of EMTALA in regards to the medical screening is that there is no disparate treatment, that everyone is treated the same way. So it is a patient's burden to establish that the hospital treated him or her differently than other patients. And I include the word hospital, but in regards to emergency medicine, be cognizant that that word will be used interchangeably between hospital and emergency room physician. Next slide, please. So if a patient receives disparate treatment, EMTALA is invoked, meaning the protections. So the key is hospital policies and procedures may describe a standard medical screening procedure for a particular condition. And while physicians oftentimes have the argument that the hospital policies and procedures do not specifically apply to them, these policies and procedures can be codified in medical rules and regulations of the emergency department, and in also medical staff bylaws. So you need to be very aware of those bylaws, rules and regs, because those flow through the medical staff and they flow through the individual credentialing process that you must be cognizant of aware of in the emergency room. So next slide, please. A medical screening further, if a patient is determined to have an emergency medical condition, then EMTALA is triggered. Stabilizing treatment must be provided. If there's no emergency medical condition, then the EMTALA obligations cease to apply at that point in time. And this is usually conducted through the triage. So the triage is key as far as in determining whether there's something that is emergent or not. And if we go to the next slide, we have the definition of an emergency medical condition. It's a condition manifesting itself by acute symptoms of sufficient severity, including pain, such that the absence of immediate medical attention could reasonably be expected to result in serious jeopardy, serious impairment to bodily functions, or serious dysfunction of any bodily organ or part. Inferred in these definitions is death as well. The key aspect of that's sometimes overlooked in a medical screen is the subjective reporting of pain. There are courts that have determined that a report of 10 out of 10 pain is by definition an emergency medical condition. And you have to be cognizant of that as far as whether or not how that is going to be investigated, elaborated on, or interpreted in the emergency room. Next slide, please. EMTALA protections also extend to pregnancies. With respect to a pregnant woman who is having contractions, that there is inadequate time to effect a safe transfer to another hospital before delivery, or that transfer may pose a threat to health and safety of the woman or unborn child. So it's really based on a time factor as far as whether or not the physician believes that you can transfer the individual in time before delivery. This has become we're seeing this issue more with the emergence of standalone emergency rooms, which are popping up in a lot of cities and neighborhoods that do not have the quick access to transfer or move the patient directly to a labor and delivery department and let the labor and delivery team handle the triage and electronic fetal monitoring and make the determination of whether or not delivery is imminent. Those capabilities do not exist in many of the standalone ERs. So you have to be cognizant about the time factors and about your documentation of how it may reflect on the time factors and recognition of how long it may take to transfer a pregnant patient from the standalone ER to the main facility to get an assessment in the labor and delivery department. So you have to be careful on the time constraints. Next slide, please. So EMTALA imposes a duty to stabilize a patient who's experiencing an emergency medical condition. And again, just based on the last slide on a pregnancy, whether or not the impending delivery can be stabilized is always a hot button topic. But any patient who has an emergency condition must be stabilized before transfer or discharge. So next slide, please. So to stabilize, what the statutory definition means is to provide such medical treatment of the condition as may be necessary to assure within reasonable medical probability that no material deterioration is likely to result from or occur during transfer of the individual or with respect to a pregnant woman to deliver, including the placenta. So ultimately, these questions, if you're ever asked these questions under oath, it always comes down to what your opinion would be under reasonable medical probability. And if within reasonable medical probability you believe you can effectuate the transfer, then that's going to be the key question. If you can't effectuate the transfer, then the care then turns to what actions do you do in order to effectuate, for example, delivery or addressing the emergency medical condition. Next slide, please. It's not limited just the emergency room. So EMTALA and the stabilization requirement can apply if it develops in other areas of the hospital. This is a much rarer type of issue, but it is out there. I'm going to, can you skip up 3 slides, please? So the general rule on transfers, if an individual at a hospital has an emergency medical condition which has not been stabilized, the hospital may not transfer that individual unless, next slide, please. The individual in writing requests a transfer to another facility, whether the physician has signed off on the transfer. The certification that everyone signs off on must include an outline of the risks and benefits, and there is a transfer to an appropriate receiving facility. So if there's a desire to let's risk it and move the patient, then these 4 categories must be completed, and the physician, emergency room physician, would do well in confirming that these 4 things are documented within the medical record and contained in the memorandum of transfers, typically where you'd want to double check that these 4 things are on there. We move on to EMTALA on-call lists. There we go. So on-call lists are another part of EMTALA. in which physicians, either consultants, typically surgeons, higher level of care type of surgeons, maybe neurosurgeons, pediatrics, PD neuros, other specialties may be on a call list to cover certain types of cases that fall within their purview. And on-call physicians have a duty to respond and evaluate a patient if a physician determines that their services are required. And the typical scenario that often arises or may arise is that a physician has decided to be on a particular facility's on-call list, and they are called by an emergency room physician because they have a patient or patients in the emergency room that the ER doctor believes or feels strongly that require the services of that on-call physician or evaluation of that on-call physician. And the issue sometimes comes down to, in that phone call, if there's some reason the on-call physician believes they don't need to come in, is whether or not that question of the requirement of outside services or the on-call physician services was clarified. And if the ER doctor's documentation that may be looked at retroactively is silent as to the reasons that alleviated the concern or the need for the outside physician services are not documented, then it's going to look like that the ER physician requested or wanted those outside services, and that the ER physician, in conjunction with the ER nurses or the ER term, failed to effectuate getting in that consult to see that patient. So obviously, if there's the consult is requested, you'd want the consult to always come in and look at that patient and then assist you, the ER physician, in determining whether or not additional care or admission of the patient needs to be done or put on the list of tasks to complete for that patient. But the other scenario is you call the on-call physician and the on-call physician decides, well, I don't think that that's my type of patient, and for whatever reason does not want to come in or believes they're not the right doctor to come in, then that issue needs to be described in the documentation in order so that if someone else is looking at this chart a year later, 2 years later, that it doesn't look like the ER physician just made a choice to do something and then it ended there. Next slide, please. So if an on-call physician fails to peer evaluate a patient and the physician, ER physician, determines that without those services of the on-call physician, the benefits of transfer outweigh the risks of transfer, the physician authorizing transfer does not violate EMTALA. Therefore, this is somewhat rare occasions, but these rare occasions are the ones that may result in lawsuits, or that if there's a disagreement of whether or not that on-call physician thinks they need to be in there and the ER physician believes they need to be seen by that type of specialist, and the ER doctor believes that the benefits of the transfer, the risks of transfer outweigh the risk of not having that evaluation, then you can defend against an EMTALA violation. The on-call physician in those circumstances, along with the hospital, not the ER doctor, the on-call physician can be seen as violating and may be culpable of violating EMTALA under those circumstances, because their obligation is to respond, and they've made a commitment to respond to requests from the emergency room physician or the emergency room team. Next slide, please. So try to wrap up the issue of on-call lists. CMS, Centers of Medicaid, hospital has discretion to maintain on-call lists in a manner that best meets the needs of its patients. if you practice in rural areas or areas where resources are less than, say, highly populated or urban areas, then you may not have every type of specialty at your disposal in regards to an on-call list, number one. Number two, even if the type of specialist is available, it does not mean that that specialist is going to be on call every single day of the month. So in areas where resources and types of specialists are limited, for example, in areas where there may be only one neurosurgeon or two neurosurgeons or only a few pediatric neurologists, those neurologists are under no obligation to be on call every day of the month 24/7. They may enter into an agreement with the facility to be on call 1 week out of the month or specific days out of the month. And obviously the issues that are dictating those on-call lists oftentimes come down to the resources and available specialists in the area. And CMS has recognized these issues. It's specialists, subspecialists are not required to be on call at all times. An example of this would be an ER physician knows of a, let's say, neurosurgeon in the area and feels that their patient is really in need of a neurosurgeon as opposed to the on-call general surgeon who may be the only person available. And just because of their prior relationship or understanding, calls that neurosurgeon, if they're not on call that particular evening, is under no requirement to come to the hospital and provide coverage. But that is also a reason that you can get around EMTALA as far as transferring the patient, again, if the risks of the keeping the patient in outweigh the transfer. I'm running a little long on time, but I do want to cover, if we move 2 slides over. One more, I think. I'm sorry, a couple more. Yes. There we go. Standards of proof in cases involving emergency medical care. So in 2003, the statute, like we discussed earlier, was changed to provide protections on damages. Another very important protection that it included was a higher burden of proof required on cases brought against emergency room physicians, emergency room departments, when they are providing emergency medical care. Not all care in the emergency room is designated as emergency medical care, but the courts have been very broad in its interpretation of emergency medical care. And there is an argument that if the care is being delivered in the emergency room, then the presumption is that it's emergency medical care that falls under the statute. And this statute has a lot of tangents of a prior no longer in existence statute, which is like a Good Samaritan statute, where if you stopped and provided medical care because you knew how to do it as a Samaritan, then you, as a Good Samaritan, you should be held at a higher standard. And if for some reason you do something that is perceived to have been negligence or alleged to have been negligence. But so this statute, in circumstances where you can fit your type of care into emergency medical care in the emergency department, then the standard of proof against that emergency room doctor is elevated from just a preponderance of the evidence, which would be what I discussed earlier. 51% of doctors think that you met the standard of care, to a willful and wanton negligence. So willful and wanton negligence, there's debates on the definition. I interpret the definition almost to indicate that there is an intent, almost an intent of knowing that you are going to cause injury, meaning it's willful negligence. You know what you're going to do is going to cause injury and you go ahead and do it anyway. That's a very, very high standard for any plaintiff or claimant to achieve. And the product of that is that this statute and this higher burden of proof gives another level of protection for emergency room physicians providing emergency room medical care. This statute has been extended recently in the last 2 years to apply to other types of emergencies, including emergencies resulting during deliveries of children, in particular shoulder dystocias, which are defined by the American College of Obstetricians and Gynecologists, ACOG, as an unforeseeable and unpredictable obstetrical emergency. And under those circumstances, the courts, the Supreme Court of Texas, has determined that this higher burden of proof should apply to those types of obstetrical emergencies. The defense side of the bar that defends physicians is trying to expand that definition more and more through other types of cases. And obviously the types of lawyers that bring cases against healthcare providers is trying to narrow that definition and that higher burden of proof to a very narrow interpretation of cases. That gets to the end of the topics that I wanted to discuss. There's more slides that kind of elaborate on the standard of proof, but they're nothing that I have not mentioned. I think I'm going to be available on October 29th and 30th for chat sessions or questions. Also, my general email box is included at the beginning of this presentation. My individual email is ecastillo@valleyfirm.com. So first letter of my first name and last name at Valley. That you have a follow-up question from this presentation, and I'll try to get that answer to you. Also, if you just want to call me anytime, the office number is there, and I will try